Oops. Okay, you guys. So we're dealing with the Supreme Court and the lower justices. All federal justices are appointed by the president, but that's not the only person who has a deciding voice. In this case, the Senate also confirms federal justices. As sort of a point of courtesy, the president will typically consult with the senators of a given state on whether or not an appointment from that state is appropriate. So let's say I was going to appoint someone to the Supreme Court from Nevada. I would, as the president, I would go and talk to the senators from Nevada, and I would get their approval. That's sort of what's called senatorial courtesy. Now, to make their decisions, the president obviously can't decide on every single federal justice appointment. So he relies on the Attorney General and the Department of Justice. The Attorney General and the Department of Justice, they're sort of the legal arm of the United States government. They represent both the executive branch and the government as a whole. So if there was a case going before the Supreme Court where it was like, for example, United States versus Nixon, the person who's on the side of the United States, that's the Attorney General. They're the ones arguing the case in favor of the United States. And the Department of Justice as a whole is the organ that facilitates that. They go through and they screen all the candidates, and they're most qualified to do that because they deal with the courts on a much more consistent basis than anyone else does. 1 out of 5 nominees will not make it. And the reason for that is that sometimes it's hard to get all the Senate to agree on. Perhaps there's a particular appointment that's too liberal or too conservative, and it'll cause a lot of problems, and the senators won't approve them. Now, when we appoint a new Chief Justice, that can either be from someone who is brand new, or it can be from someone who is already on the Supreme Court. So we can bump up someone. Let's say Chief Justice John Roberts retired. We can now appoint maybe Clarence Thomas as the next Chief Justice of the Supreme Court. And then we could also get a new justice to replace his former regular justice seat. On this graph, what we see is the importance of selecting a Supreme Court justice. Now, a president can only rule for a max of 8 to 10 years, depending on whether or not they manage to get into the presidency on a previous term. Now, because they only last for 8 to 10 years at a max, they have to find some way to sort of extend their influence. One way to do that is by electing Supreme Court justices or appointing Supreme Court justices. And the ones who last the longest obviously have the most influence on the Supreme Court. So here you can see a couple were appointed under Reagan. And because they were appointed under Reagan, they tend to be more conservative, both Scalia and Kennedy. They tend to be conservative, and they are both currently on the Supreme Court. Clinton appointed Breyer, and you can see generally more liberal because that was Clinton's. If we look in today's, we have G.W. Bush appointed Chief Justice John Roberts and Samuel Alito, whereas Obama has appointed Sotomayor and Kagan. And so these two justices tend to vote conservatively, and these two justices tend to vote a little bit more liberally, and that's because Obama selected these ones and Bush selected these ones. And so this is a way for the president to extend their influence. Now here's an example of how the former Chief Justice, Rehnquist, retired. And a new Chief Justice was appointed. And this Chief Justice was not someone who had been a Chief Justice or had not been a justice prior. So this was a new person selected as the Chief Justice. Now, this is an organization of how the Supreme Court is organized. You have the Chief Justice sitting right there in the middle, and the various other justices sitting to his sides. Now, there's only one table in front of them because we only have one representative from each side talking at a time. There's no back and forth here with the two sides, say a plaintiff over here and a defendant over here. Nope, there's only one right here in the middle. And they will present their case, and the justices will ask questions if they so desire. There's a little red light that they can see, and once their time is up, they must stop talking. And that's the time that now the justices can ask them questions. And they'll ask many technical questions when it comes to constitutional law and whether or not rights have been violated in some way or another. Now, an important part of the Supreme Court is its ability to direct policy. As I said before, the Supreme Court accepts cases when there are 4 of the Supreme Court justices who decide, yes, we want to hear that case. And they issue what's called a writ of certiorari, which means, hey, let us see how that case was decided, and we're going to make a decision on that. Now, there's very few actually accepted each year, and that's because there's 7,500 cases that the Supreme Court reviews. There's too much to decide on. These come from both federal courts and state courts. And so what they do is the appeals are discussed. 98% of those are rejected. 2% have received the required 4 votes. And because they've received the 4 votes, they are then placed on the docket. They're given a date and a time for arguments and for arguments to occur. Now, once the case is on the docket, both sides must submit a brief, which it describes their argument. They will then have a date assigned where they get to argue in front of the Supreme Court. Not necessarily argue, but present their argument. And it's at that time that the Supreme Court justices get to question the two sides. After that, the justices hold a conference and they take a vote. And they start writing opinions. And that's assigned, like I said, by the Chief Justice of the Supreme Court. Once opinions have been drafted, they're sort of passed around between the justices for each other to sort of add comments, add critiques, and maybe add some extra information. And once the final draft has been created, then the decision is announced. Now, it's important to understand a few terms here. One is opinion. The opinion is the legal reasoning of the decision. So the Supreme Court might rule 6-3 in a particular case. Well, they're going to give the legal reasoning behind that, and that's called the opinion. And so the 6 people who voted one way, they will have the opinion. And the Chief Justice of the Supreme Court, he decides who writes that opinion. Now, they might decide to let the previous decisions stay. So if a case had been decided years ago, they'll say, no, that's probably good enough, and we'll just let it stay that way. The decision of the lower court in this case is good, so we'll leave it that way. And they might not say anything about it. Now, they might choose to go back into the past and look at what previous cases have been decided. That's called precedent. Now, they might choose to follow that or reject that. It just depends. Also to note is original intent. Sometimes the Supreme Court justices sort of try to interpret what the Founding Fathers meant when they said certain things. We don't know everything the Founding Fathers meant. In fact, many of the Founding Fathers didn't agree with each other. So interpreting this original intent, that's really left up to the Supreme Court. Now, in decisions, you might have people who dissent, or people who don't vote with the majority. So in the case of 6-3, the 3 justices who disagree, they might write what's called a dissenting opinion, and they'll give their reasonings on why they disagree. Now, there's 2 major philosophies for being a Supreme Court justice. One is restraint, and the other is activism. Restraint means that these judges feel like they shouldn't play a big part in determining policy, that should be left to the legislative branch. They're the ones who make the laws. We only need to make sure that those laws don't go crazy. Activism, on the other hand, judicial activism, means that the Supreme Court has a role in shaping policy, that they should take those hard cases and issue decisions that shake up the current landscape. They might decide that certain things are completely invalid based on the Constitution, like Brown versus Board of Education, completely tearing up segregation of schools, and that changed the direction of the nation as a whole. Now, on this last slide, we have a couple of important things you need to remember. When dealing with smaller cases, district court cases, cases that you might be involved in, we're going to define a couple terms here. One is a grand jury. A grand jury is a group of persons, they're called a jury, that decide on whether or not someone should be tried. They do not decide on whether or not the person's guilty. They merely look at the evidence and say, yes, there is enough evidence there for us to go get the guy, bring him in, and put them on trial. Now, the petit jury, they're the jury that you're most used to seeing. You know, the 12 jury members who decide whether or not a person is in fact guilty. They'll issue the verdict. And the last term here that I want you guys to remember is due process. Due process is very important. This is the thing that you appeal on when you don't like the decision for your case. You say, oh, my due process, I didn't receive due process. So what things qualify for due process? Mainly, it's whether or not there was fair and an impartial trial, meaning that they followed all of the procedures and laws, as we mentioned. So let's say someone didn't present evidence that they had in secret. That would be something that would be appealable because due process wasn't given. Or if someone confessed when they weren't informed of their rights, that would definitely be a due process violation. And you have to make sure due process has been satisfied before you can take away life, liberty, or property. Remember, that's John Locke's idea that said, the essential role of government is to ensure life, liberty, or property. And you better have a dang good reason, in this case due process, for taking that away from someone. Okay, that's the second video. I might put up a third video describing some important cases, but please read these ones and take notes. I will see you guys in the next video presentation.